Hi there, this is John Cann from Cann and Associates, and today I'm going to be speaking to the issue of whether someone should take a plea deal in their criminal case in Oklahoma. Oftentimes when clients come to us, or family members of clients come to us, they're wondering whether they should take what the state is offering, what that means, versus whether they should go to trial. So we're going to dive into that. So the question of should I take a plea deal in my criminal case in Oklahoma? Well, first off, what is a plea deal? A plea deal is where the government, whether it's the U.S. Attorney's Office, Military Justice Department, the state attorney, district attorney's office, municipal prosecutor, other prosecuting office is willing to offer a plea deal or an agreement to the defendant or their defense attorney to allow them to resolve the case without having to go to trial. And some of the reasons that parties would consider doing that are the following. One, the district attorney, U.S. attorney, prosecutor may want to offer a plea deal so that they don't have to prosecute that case. They may have witness issues, they may have evidentiary issues. They also have judicial resource issues that they have to consider, and they can't take every case to trial. So some cases have to be resolved, or the majority of cases have to be resolved by either a plea agreement or by some other type of disposition. So let's dive into what your options are in a criminal case. So there's really three general options that you have in a criminal case, and they're the following. One, you can, like we're discussing today, work out a plea deal with the government, enter into an agreed disposition. We can talk about what that means in a moment. Two, you can enter into what's called a blind plea, where you resolve your case, but you do not know the outcome. And in that case, the judge decides what your sentence will be, a topic we can dive into deeper on another day. And third, you can contest your case, and that can be through motion practice to contest an aspect of a traffic stop or an encounter with law enforcement or sufficiency of evidence or move to exclude some key piece of evidence or even a jury trial, where witnesses would appear, testify in front of a jury. Your attorney would have the opportunity to cross-examine them and eventually make argument to try and convince the jury that you are not guilty of your offense. Almost every criminal case in Oklahoma or any state, whether it's federal prosecution, state prosecution, a military-specific offense, is resolved in one of these three ways: by agreement or a plea deal, by alternate distribution of a blind plea where the judge decides the outcome, or finally contesting the case all the way through jury trial or appeal. So one of the things that we often encounter is individuals that are represented by other criminal defense counsel, and they simply appear at the first date and resolve the case. And that's something we want to make sure that you avoid. So the second point I want to talk about is research and looking into your case. So when someone is charged with a crime in Oklahoma, take state court for instance, they're charged with specific misdemeanor or felony offenses. And each one of those offenses has a statutory reference, it has a punishment range that's applicable, and there are elements that the government has to meet in order to find or prove your guilt beyond a reasonable doubt, elements that must be met by the government. And if the government can't prove every single one of those elements to a jury or to a judge, then you would be held or found not guilty of that offense if you take your case to trial. So the government has the burden. They have to have sufficient evidence in order to prove your guilt, and it's important that your attorney does research and make sure that the government could meet that burden if you choose to force them to take your case to trial. So what does that consist of? Well, there's the police reports or the investigative reports that need to be looked into. Is there sufficient evidence through witness testimony, through eyewitness identification, through other types of direct evidence, through circumstantial evidence? You're found in close proximity to where this crime occurred, and your state, when you were discovered, would indicate that something had happened recently. You may have been involved in some incident, including potentially the crime that you're charged with. Is there photographic evidence that's inculpatory or shows your guilt? Is there DNA evidence? Is there other types of forensic evidence? Is there dash cam footage? Is there body cam footage of police officers? Is there body mic audio recordings? Is there sufficient evidence that if the government were forced by you or your criminal defense attorney to present that case at trial, that they would be able to prove your guilt beyond a reasonable doubt? And it's important that your criminal defense attorney goes through the process of researching the evidence, ensuring that the government doesn't just claim, but can show that they have the necessary evidence that if they were forced to, they could prove your guilt at jury trial before you decide to accept a plea agreement. And then next is three, suppression. Are there legal problems? Did the police stop you without a valid basis? Did law enforcement conduct a search without the exigency required if they didn't have a warrant? The Supreme Court has stated long, long ago, and hundreds of cases since, precedent stating that there must be a warrant executed by a judge who's not involved in the facts of the case, who is detached magistrate, or is there an exigency or an emergent circumstance that gives the law enforcement the authority to, in that moment, without a warrant, execute a search. So if the government can't show that there's a warrant and the government can't show an exigency, then there may be an invalid search, which should result in suppression of or exclusion of that evidence from your criminal trial. Other issues that may be considered. Is there insufficient evidence to meet one of those elements we discussed earlier? If you're charged with one single offense and the government can prove beyond a reasonable doubt 3 out of the 4 or 4 out of the 5 elements, but the government will not be able to prove that last element, then that's insufficient evidence. There could be a motion to quash filed before jury trial even to show that the government can't meet their burden and you should not take a plea deal in that case. So you want to make sure that your criminal defense attorney is looking into the legal issues, researching what the government can or can't prove, ensuring that all the legal requirements for a proper investigation, for a proper traffic stop or citizen stop, for a proper arrest, for everything that should happen, happens in that case, happens lawfully against you before you're charged, that you're charged with the appropriate offenses, and that the government can meet their burden of beyond a reasonable doubt in those offenses before you consider taking a plea deal. Next, the fourth element, just spoke to that a moment ago, but dive into a little bit deeper, burden of proof. So there's no higher burden in any jurisdiction or any type of proceeding in the United States than in the criminal justice system, and that is beyond a reasonable doubt. The government must prove beyond a reasonable doubt your guilt of every single element of every single offense that you're charged with in order to prove you guilty to a jury. And in the state court and in the federal criminal court system, as well as municipal, the government must prove your guilt beyond a reasonable doubt to a unanimous jury, which means that if one juror out of 12 in a criminal trial does not believe beyond a reasonable doubt that you are guilty, then you cannot be found guilty in that trial. Now, there's different circumstances with the military. That's an issue we can get into another day, but you, in fact, can be found guilty in a very serious court-martial proceeding without a unanimous panel or without a unanimous jury. So if you're charged with military-specific offenses, that's something we can speak about in another day. But the burden of proof in state court, federal criminal court, and municipal court proceedings is a jury must find you unanimously guilty, and the government must prove your guilt beyond a reasonable doubt, and no higher burden exists in the United States. It's important that before you choose to accept a plea offer by the government, you and your attorney have spoke about what that burden means and whether the government can meet their burden in your case and what evidence you can present to show that they cannot meet that burden, and whether you decide to proceed with your case going through motion practice to fight your charges, whether you decide to go to jury trial and hold the government to their burden to prove your guilt beyond a reasonable doubt, or if you decide to consider taking a plea deal in your Oklahoma criminal case. It's important to ensure that you've discussed these issues with your criminal defense attorney, considered the 3 options in your case, considered the research and what does the law look like, what do the facts look like, what is the evidence that the government has. Suppression, what legal issues may there be? Are there insufficiency of evidence issues? Was there an unlawful search? Was there an unlawful stop? Things that you can raise to the court. Has the government shown that they can meet their burden of proof of beyond a reasonable doubt, the highest burden in the United States, before you decide to accept a plea deal from the government? And if that's the case, and you think that the best option for you after the advice of your criminal defense attorney is to accept a plea deal in your case, have you and your attorney talked about mitigation? Have you and your attorney talked about circumstances, extenuation, things in your life, things with your mental health, the substance issues you may be going through, mental health history that you've suffered, things that have gone on in your personal life, events that don't excuse your conduct, but events that explain what led you to the place that you were at, that led to the decisions you made. They may have been your choices, but there are things that contribute to the things that happen in everyone's life. Have you and your attorney gone through those issues? Have you ensured that your attorney has presented that to the prosecutor, whether it's a U.S. attorney, a state court, district attorney, or your municipal prosecutor, in the best way possible to preserve those issues and make sure that that prosecutor doesn't just see you as a number, doesn't just see you as a criminal case, but sees you as the person behind those charges and what may have led to the place that you were at that day or that night that these events took place. Because in every single case, the district attorney or the U.S. attorney is going to have initial position on how your case could be resolved. They will have your criminal background if you have one. They'll have an NCIC report or III that shows your criminal history from arrest through any conviction or anything in between. They will see what your page 2 looks like or prior convictions if you have them. They will see what the allegations are that night or the victim or complaining witness's perspective. But what they don't automatically have is your story. And it's important that before you accept a plea deal in Oklahoma in your criminal case, that you and your criminal defense attorney have presented your side, have presented your story, have shown the humanity of where you were, what was going on in your life that led to you doing what you may have done, that you're ready to take responsibility for. So it's important that you ensure that all of these 5 steps are gone through in detail and explained to you, and you've worked through and understand each and every step in this process before you agree to accept your plea deal. 95+% of cases in the state of Oklahoma, or really anywhere in the country, at any of the types of criminal jurisdictions that I just spoke of, are resolved by a plea agreement. And there's a number of reasons that the state, with the amount of cases they have to handle and their limited resources and the potential negative outcomes for them, the potential detriments of forcing their witnesses or their victims going through the process of testifying in front of a jury, potentially bringing up painful memories, being cross-examined by criminal defense attorneys who have years of experience of attacking witnesses on specific issues. There's a number of reasons why the state doesn't want to go through the pain of a jury trial. And conversely, a defendant or our clients have a number of reasons they don't want to either. The punishment ranges on almost every offense in the state of Oklahoma can be harsh. For misdemeanors that carry a year in jail, 365, to felony offenses, many of which carry life in prison. It's important that you consider all of these factors and evaluate your options before you decide to give up the opportunity to work out an agreement with the state and mitigate the consequences before you give up your opportunity to take your case to jury trial. At Cannon Associates, we're dedicated to fierce advocacy for anyone or any family that trusts us with their criminal case or what they're facing. If you have any questions about these issues or any other questions about criminal defense, we welcome you to contact the fierce advocates at Cannon Associates. We'd be happy to set up a consult with you and explain these issues in more detail.